Ma'am, you need to stop resisting and get on the ground.
I'm standing still with my hands
You're
visible.
being belligerent. Get down now.
Officer, I'm a sitting federal judge. You're making a serious mistake.
I don't care who you think you are. On the ground.
My hands are empty. I'm not a threat, and your camera is recording this. But understand that every second of this is being recorded, and you're violating clearly established laws.
A stark command cut through the mundane sounds of a parking lot. Ma'am, you need to stop resisting and get on the ground. The woman stood motionless, her hands calm and visible. Her voice, however, carried an unwavering authority. Resisting? My hands are empty. Officer, I am a sitting federal judge. You are making a serious mistake. The officer, David Hutchkins, ignored her. He saw only defiance. I don't care who you think you are. Get down now. His tone was absolute, dismissive of any claim of authority other than his own. The woman's next words were a chilling forecast. Your camera is recording this. Every second of this is being documented. You are violating established law. This wasn't a plea. It was a formal declaration of fact, delivered under duress. Officer Hutchkins was 36 years old, an 8-year veteran of the San Diego Police Department. He had no way of knowing the woman he was about to arrest had spent the last 19 years on the federal bench. She had presided over cases involving police misconduct, civil rights violations, and the very Fourth Amendment abuses he was committing in that moment. The woman in casual clothes, standing by her black Mercedes, was Judge Keisha Langford. She had sent corrupt officers to prison and crafted legal opinions that shaped jurisprudence across 3 states. Now, she was about to become the central figure in a lawsuit that would dismantle careers and cost the city hundreds of thousands of dollars. Judge Langford was not a person who sought special treatment. At 52, her career as a federal judge had been marked by fairness and an unyielding commitment to legal standards. She had overseen everything from death penalty cases to complex civil rights litigation. Her reputation was impeccable. This Saturday afternoon, she was simply running errands. She had purchased items for her home at a high-end mall in La Jolla. Now she was loading shopping bags into the trunk of her Mercedes. The car was hers, registered, and she held the key fob. She was engaged in an activity thousands of Americans perform daily. But then, a voice shattered the quiet afternoon. Ma'am, step away from the vehicle. Keisha turned. Officer Hutchkins approached, his hand resting on his service weapon. He was responding to a vague, suspicious person call. The description: black female, medium build, near expensive vehicles. That was the extent of it. No specific suspicious behavior, no reported theft. Just a black woman near an expensive car. Hutchkins had immediately concluded Keisha was his target. What the officer interpreted as suspicious would soon redefine his entire career. Keisha kept her hands visible, the key fob still clutched in one. Is there a problem, officer? Hutchkins' demand was immediate. I need you to step away from the vehicle and show me some identification. Keisha's trained legal mind instantly recognized the situation. This was a Fourth Amendment seizure. He had detained her without reasonable suspicion of criminal activity. She had a choice: comply silently or assert her rights. She chose the latter. Officer, I'm loading my own car with my own purchases. I have the key fob. What reasonable suspicion do you have that I'm engaged in criminal activity? Hutchkins clearly disliked the challenge. Most people he stopped simply complied. Ma'am, I'm investigating a suspicious person report. I need to see your ID. Keisha pressed further. What specific suspicious behavior was reported? Because loading shopping bags into a car isn't suspicious. What crime do they believe was being committed? Hutchkins' grip tightened on his weapon. This wasn't just a confrontation. It was a carefully calculated legal chess match playing out in a public parking lot. Ma'am, you need to cooperate. Keisha remained composed. I am cooperating. I am asking you to articulate the legal basis for this stop. That is not obstruction. That is my constitutional right. The confrontation escalated. Other shoppers slowed, some pulling out phones to record. I'm not going to ask again, Hutchkins stated. Step away from the vehicle and provide identification. Keisha made a tactical decision. She would comply under protest, document everything, and pursue legal recourse later. Arguing further in a parking lot, especially for a black American, carried unnecessary risk. Officer, I will comply, but I want to state clearly that this stop lacks reasonable suspicion and violates my Fourth Amendment rights. I am reaching for my wallet now." She moved slowly, deliberately, her hand always visible. From her purse, she retrieved her wallet. It contained her driver's license, her federal judge identification, her courthouse security credentials, and her California bar card. She handed Hutchins her driver's license first. Hutchins examined the license, Keisha Langford. He cross-referenced the address with the vehicle's registration, visible through the windshield. "This your car?" he asked. "Yes," she confirmed. "Prove it." Keisha held up the key fob, pressed the lock button, and the Mercedes lights flashed, locks clicking. She pressed unlock. The lights flashed again, the locks opening. "Satisfied?" she asked. Hutchins should have ended the encounter then. He had detained someone loading their own belongings into their own car. There was no crime, no violation, no reasonable suspicion. But Hutchins had a problem. Witnesses were watching, and he had already escalated the situation. Backing down now would appear weak, so he doubled down. "You're being belligerent and uncooperative. I'm going to need you to wait here while I verify this information." A single decision, driven by pride, was about to transform a minor incident into a national scandal. Keisha felt anger stir, but she maintained control. "Officer, I've provided identification. I've demonstrated vehicle ownership. There is no legal basis to continue this detention. Am I free to go?" "No," Hutchins replied. "You need to wait while I run your information." "On what grounds?" she asked. "On the grounds that I'm conducting an investigation." "An investigation into what crime?" Hutchins offered no answer. He walked back to his patrol car with her license. Keisha stood by her Mercedes, hands visible, making eye contact with the woman recording the incident. She gave a small nod. "Keep recording. This matters." Hutchins sat in his patrol car, running Keisha's license. The system returned a clean record, no warrants, no criminal history, a perfect driving record. The registered owner matched the license. Everything checked out. He should have returned her license, apologized, and released her. Instead, he faced a new dilemma. He had made a bad stop and continued it well past the point of reasonableness. He needed a new justification. He exited his patrol car and approached Keisha once more. "Ma'am, I'm going to need to search your vehicle." Keisha's eyes narrowed. "On what basis?" "I have reasonable suspicion that there may be stolen merchandise in the vehicle." "Based on what?" she challenged. "I have receipts for everything. The bags are from stores in this very mall. Your reasonable suspicion is based on what specific articulable facts?" Hutchins was cornered. He had no facts, only a vague report and his own assumptions. This was not reasonable suspicion nor probable cause. It was bias. "Ma'am, you're being uncooperative." "That gives me reasonable suspicion." Keisha almost scoffed. "No, officer, it doesn't. Asserting my constitutional rights is not evidence of criminal activity. Arizona versus Johnson establishes that clearly. You cannot use my refusal to consent to a search as justification for reasonable suspicion." Hutchins' face flushed. "Are you a lawyer?" Keisha delivered the statement that would bring the parking lot to a standstill. "I'm a federal judge." The background noise of traffic and shoppers seemed to vanish. Hutchins stared, stunned. "You're a what?" "A federal judge," she reiterated. "United States District Court, Southern District of California. I've been on the bench for 19 years. You've just violated my Fourth Amendment rights in a way so clearly established that you won't be able to claim qualified immunity." The gravity of this single statement would ripple through an entire police department. Hutchins' hand moved away from his weapon. His posture shifted, uncertainty clouding his face for the first time. "I need to see proof of that." Keisha calmly reached into her wallet again, producing her official United States Court's identification. It displayed her photograph, name, title, and the federal judiciary seal. Hutchins took the credentials. His hands trembled slightly. "This could be fake," he said, his voice now devoid of its earlier authority. "Call the federal courthouse," Keisha instructed. "The main number is public. Ask for Chambers. They'll confirm my identity." The woman who had been recording spoke up from 20 feet away. "I've got all of this on video, everything." Hutchins looked at the recorder, then back at Keisha. "Ma'am, I'm going to need you to step away from the vehicle." "We're past that point, officer," Keisha said, her calm unwavering. "You've already detained me unlawfully. You continued the detention past any reasonable time frame. You requested a search without probable cause. Now you're escalating because you've realized your mistake. What you should do is return my identification, apologize, and call your supervisor." "I don't have to do anything." "Actually, you do," Keisha countered. "I'm not just going to file a complaint. I'm going to file a federal lawsuit. Every decision you make in the next 60 seconds is going to be evidence in that lawsuit." Hutchkins made the worst decision of his career. Instead of de-escalating, instead of calling a supervisor or admitting error, he chose to assert his perceived authority. "Ma'am, turn around and place your hands behind your back." "For what?" Keisha demanded. "You're under arrest for interfering with a police investigation." "There is no investigation," she stated. "There is an officer who saw a black woman in an expensive car and made assumptions. But if you're going to arrest me, do it. The video is rolling. My credentials are in your hand. You are about to make the biggest mistake of your career." Hutchkins pulled out his handcuffs. Keisha turned slowly, placing her hands behind her back. The metal clicked around her wrists. The woman recording was now on her phone. A small crowd of shoppers formed, murmuring. "What's happening?" one asked. "The police are arresting a federal judge for loading groceries into her own car," another replied. Hutchkins walked Keisha to his patrol car. She offered no resistance, no argument, just walked calmly, her head held high, her expression unreadable. He placed her in the back seat. The plastic was hard. The car smelled of stale coffee and disinfectant. Keisha sat perfectly still. Her mind was already assembling the legal strategy, preserving evidence, identifying witnesses. Hutchkins sat in the front seat, picking up his radio, then putting it down. He knew he had made a catastrophic error, but he had committed to the arrest. There was no easy way to reverse course without appearing incompetent. He started the car. The drive to the police station took 11 minutes. Neither officer nor judge spoke a word. The silence in the patrol car ended as Hutchkins pulled into the police station. Inside, the usual hum of activity continued. Other officers glanced up, seeing a well-dressed black woman in handcuffs, but showed little initial interest. It was a common sight, unremarkable until details emerged. Hutchkins escorted Keisha to the processing area, where Officer Carmen Rodriguez, a seasoned 12-year veteran, began the standard booking procedure. Rodriguez started cataloging Keisha's personal belongings: phone, keys, wallet, jewelry. When she opened the wallet, her movements paused. Inside, plain for anyone to see, were the federal judge credentials. Rodriguez looked at the ID card, then at Keisha, then at Hutchkins. Her expression didn't betray emotion, but her questions were direct. "Where did you arrest her?" she asked quietly. "Parking lot of the mall in La Jolla." "What was she doing?" "Loading shopping bags into her car." Rodriguez's eyes hardened. "What were the charges?" "Interfering with an investigation." "What investigation?" "A suspicious person report." Rodriguez held up the federal credentials, her gaze fixed on Hutchkins. "Did you verify these? I think they might be fake." Rodriguez had processed thousands of arrests and seen every conceivable type of forged identification. These were not fake. The holographic seal, the microprinting, the texture and weight, everything pointed to authentic federal court credentials. What the officer didn't realize was the institutional earthquake he had already set in motion. Without another word, Rodriguez stepped away from the processing desk and walked directly to her watch commander's office. Lieutenant Marcus Freeman, a 21-year veteran of the San Diego Police Department, had handled his share of difficult situations. But as Rodriguez entered his office, holding federal judge credentials, his stomach dropped. "Where's the person these belong to?" Freeman asked. "Processing area." Hutchkins brought her in, arrested her for interfering with an investigation. Freeman immediately stood. He walked to the processing area, his eyes scanning Keisha, who sat calmly in a holding chair. He looked at the credentials again, a grim realization dawning. Returning to his office, he closed the door. He placed a call to the duty assistant chief. The conversation was brief, lasting only 3 minutes. When Freeman hung up, he looked noticeably older, the weight of the moment etched on his face. The implications of that 3-minute call would reverberate through the entire department. Freeman returned to the processing area, his voice now deferential. "Judge Langford, I'm Lieutenant Freeman. I apologize for this situation. You're being released immediately." Keisha's response was not one of relief, but judicial inquiry. "What was I being charged with?" "That's being reviewed," Freeman replied, attempting to sidestep. "I want everything in writing," Keisha stated, her voice firm. The initial call report, the body camera footage, the dash cam footage, the booking report, Officer Hutchkins' written statement of probable cause, everything. Freeman nodded, knowing full well the depth of her demands. "We'll have those ready for you within 24 hours. I want them tonight." There was no room for negotiation. Freeman recognized the tone of a judge making a ruling that demanded immediate compliance. "I'll make sure you have them tonight." Her demands were not for justice. They were for an undeniable paper trail. Keisha was uncuffed, her belongings returned. Lieutenant Freeman himself escorted her out, apologizing repeatedly. She called an Uber and arrived home at 6:47 that evening. She had been detained for 2 hours and 33 minutes. Sitting in her living room, she allowed herself a moment to process the events. Then, she picked up her phone. The first call went to the Chief Judge of the Southern District of California. The second was to a longtime friend, a civil rights attorney. The third, to the American Civil Liberties Union. By Monday morning, the incident was already being discussed at the highest echelons of both the federal court system and the San Diego Police Department. The chief of police personally called Keisha to apologize. She listened politely, then informed him she would be filing a federal lawsuit regardless. The lawsuit was filed on Wednesday. 23 single-spaced pages, replete with citations to Supreme Court cases and precise timestamps from the video and body camera footage. It alleged unlawful detention, unlawful arrest, Fourth Amendment violations, 14th Amendment equal protection violations, and racial profiling. Officer Hutchkins was named individually, alongside the city of San Diego. The city attorney's office immediately reviewed the case. They watched the parking lot security footage. They reviewed the body camera footage. They read the meticulously drafted lawsuit. An emergency meeting was called with the police chief and the city manager. "This is indefensible," the city attorney stated bluntly. "We detained a federal judge for loading her own car. The video shows it clearly. We have no legal defense. We need to settle." The city quickly understood the depth of the crisis, but they hadn't anticipated the public fallout. Before settlement negotiations could even begin, the story leaked to the media. Local news outlets picked it up first, then national publications, followed by legal journals. "Federal judge arrested while shopping" became a headline that spread across the country. The parking lot video, recorded by the civilian witness, was posted online. Within 24 hours, it amassed 3 million views. Within a week, it had surpassed 15 million. The comment sections exploded. People shared their own stories of racial profiling. Legal experts meticulously dissected every constitutional violation Hutchkins had committed. Civil rights organizations seized upon the incident as undeniable evidence of systemic problems in policing. This wasn't just a legal battle. It was becoming a national conversation on policing itself. The San Diego Police Department launched an internal investigation. Their most senior internal affairs investigator was assigned to the case. The investigation spanned 4 weeks. Hutchkins was interviewed multiple times. Every second of available footage was scrutinized. The vague, suspicious person call that initiated the entire chain of events was re-examined. The findings were damning. The initial call had come from a mall security guard who admitted he thought Keisha looked out of place near expensive cars. When pressed, he could not articulate any specific suspicious behavior, only a feeling. The internal investigation concluded that Hutchkins had responded to that vague call and immediately focused on Keisha, based solely on her race. He had detained her without reasonable suspicion. He had continued that detention well past any reasonable time frame. He had requested a search without probable cause, and he had arrested her for the act of asserting her constitutional rights. Every single action he took constituted a violation of both department policy and constitutional law. The internal inquiry also uncovered a disturbing pattern. Over the preceding 3 years, Hutchkins had stopped black motorists at a rate 2.8 times higher than the department average. His searches of black motorists were 3.4 times higher. His arrest rates showed similar disparities. The pattern had been evident for years, but nobody had connected the dots. Now the oversight was undeniable. The consequences, both for Hutchkins and the department, were just beginning. Officer David Hutchkins was terminated 6 weeks after the incident. His termination letter cited multiple violations: unlawful detention, unlawful arrest, racial profiling, violation of department policy, and conduct unbecoming an officer. He attempted to appeal the decision, but his union representative, after reviewing the footage, delivered an unvarnished assessment. "You're finished. The video is too clear. The victim is too credible. The violations are too obvious." Hutchkins withdrew his appeal. His career in law enforcement, once a source of pride, was over. But this termination was merely the initial tremor before a much larger earthquake. The ripple effect extended far beyond Hutchkins' badge. The Department of Justice Civil Rights Division initiated its own investigation into the San Diego Police Department's stop and search practices. They sought to determine whether Hutchkins's bias was an isolated anomaly or a symptom of deeper, systemic problems within the force. This was not merely an individual officer's mistake. It was now a federal inquiry into the very structure of policing in San Diego. The DOJ investigation took 8 months. They meticulously analyzed 5 years of stop data, reviewed thousands of police reports, and interviewed dozens of officers and community members. The findings, released in a stark 97-page report, were damning. Black residents in San Diego were stopped at rates significantly higher than white residents, even after controlling for crime rates and population density. Black motorists were searched at rates 3 times higher than white motorists, despite being less likely to be found with contraband. The data painted a clear, undeniable picture of racial disparity. The pattern of misconduct was endemic, not incidental. In response to the DOJ's findings, the San Diego Police Department entered into a consent decree. This wasn't a voluntary agreement. It was a legally binding federal mandate for comprehensive reform. The reforms were extensive: mandatory implicit bias training for all officers, an early warning system to identify officers with problematic patterns of behavior, a civilian oversight board vested with real authority, regular audits of stop data disaggregated by race, a requirement for all uniformed officers to wear body cameras, and 3 years of federal monitoring. The single act of detaining a federal judge had forced an entire department into systemic overhaul. Meanwhile, Keisha Langford's lawsuit concluded. 9 months after the incident, the case settled. The exact settlement amount was never publicly disclosed, but sources familiar with the negotiations indicated it was $675,000. Keisha did not keep a single cent. She donated the entire settlement to civil rights organizations dedicated to police reform. Her only public statement on the matter encapsulated her true objective. "I don't need the money. I need the system to change. I need other people who don't have my resources and position to be protected from what happened to me." Her personal victory became a collective resource for broader change. The parking lot security footage, the same video that exposed Hutchkins' actions, became a mandatory training tool. It was shown in police academies across California, used in constitutional law classes, and integrated into community education. Sessions by civil rights organizations. A 2-hour detention in a parking lot had triggered a cascade of consequences: a terminated career, a substantial financial settlement, a federal consent decree, and systemic reforms that fundamentally reshaped an entire police department's operations. David Hutchkins never worked in law enforcement again. His termination for cause rendered him unhireable by other agencies. He attempted to transition into private security work, but struggled to maintain employment. He eventually left California entirely. He granted one interview to a local news outlet, still clinging to the narrative that he had merely been following his training and that the judge had been uncooperative. The interviewer pressed him, asking if he had watched the footage. Hutchkins confirmed he had. The interviewer then asked what specific suspicious behavior Keisha had engaged in. Hutchkins couldn't answer. The truth, captured on video, was irrefutable. Keisha Langford returned to the federal bench. Her colleagues noted that the experience deepened her already profound attunement to civil rights issues in her courtroom. In private conversations, Keisha often remarked that her experience wasn't unique, it was simply documented. She understood that thousands of Black Americans faced similar treatment daily, but without the federal credentials, the legal knowledge, or the resources to fight back. This realization fueled her decision to make the footage public and to donate the settlement. Her ordeal became a powerful teaching moment, exposing racial profiling in its starkest form. It demonstrated that assumptions are not evidence, and bias is not reasonable suspicion. The security camera footage remains online, a permanent record of accountability when the system, against all odds, actually works. This was the moment the officer's story, built on assumptions, finally collapsed under the weight of the undeniable evidence. Officer David Hutchkins' termination was not merely the loss of a job. It marked the definitive end of his career in law enforcement. His record, citing unlawful detention, racial profiling, and conduct unbecoming an officer, rendered him permanently unhireable by any other agency. This was more than just a punishment. It was a professional death sentence. Hutchkins attempted to find work in private security, but his past followed him. He struggled to maintain employment, his disciplinary record a consistent barrier. Eventually, he left California entirely, retreating from the public eye. He granted one interview to a local news outlet, still attempting to justify his actions. He claimed he had been following his training and that Judge Langford had been uncooperative. The interviewer, however, pressed him on the undeniable evidence. Had he watched the footage? Hutchkins confirmed he had. The interviewer then asked the critical question: what specific suspicious behavior had Judge Langford engaged in? Hutchkins, despite his repeated claims, could not articulate an answer. The visual truth, recorded for the world to see, completely undermined his narrative. The lack of an answer highlighted not just a failure of memory, but a failure of legal reasoning and integrity. While Hutchkins grappled with the personal fallout, the ripple effects continued to reshape policing. The Department of Justice Civil Rights Division's comprehensive investigation into the San Diego Police Department led to a pivotal outcome. The 97-page report meticulously detailed systemic racial disparities in stops and searches, confirming that Hutchkins' actions were not an isolated incident, but symptomatic of a broader institutional issue. The result was a legally binding consent decree, forcing the San Diego Police Department into mandatory wide-ranging reforms. These included mandatory implicit bias training for all officers, the implementation of an early warning system for problematic officer behavior, and the establishment of a civilian oversight board with genuine authority. Regular audits of stop data, disaggregated by race, became standard practice. Every uniformed officer was required to wear body cameras, and the department operated under federal monitoring for 3 years. The consequences of one officer's bias had fundamentally altered an entire police force. Keisha Langford's lawsuit against Hutchkins and the city of San Diego concluded with a settlement 9 months after the incident. The undisclosed amount, reported to be $675,000, was entirely donated by Keisha to civil rights organizations. Her public statement was clear: "I don't need the money. I need the system to change." She understood that her position offered a unique opportunity to demand accountability, an opportunity not afforded to many. The parking lot security footage, which captured every second of Hutchkins' unlawful actions, transformed into a powerful educational tool. It became required viewing in police academies across California, a stark case study on constitutional violations. Constitutional law classes used it to illustrate 4th and 14th Amendment principles. Civil rights organizations utilized it in community education sessions, showing precisely what racial profiling looked like in practice. This was not abstract legal theory, it was raw, undeniable proof. Keisha Langford returned to the federal bench, resuming her duties. Her colleagues observed that the experience had intensified her already sharp focus on civil rights issues within her courtroom. In private conversations, she would often remark that her experience, while personally distressing, was not unique. It was simply one of thousands of similar encounters that occurred daily across America. But hers was documented, meticulously and undeniably by multiple cameras. This distinction was critical. She often reflected on the profound disparity. Thousands of Black Americans endure similar treatment, yet lack federal credentials, legal knowledge, or the resources to effectively fight back. This realization underscored her decision to push for the footage's public release and to donate her settlement. The incident, therefore, transcended a personal legal victory. It evolved into a powerful teaching moment, designed to educate both the public and law enforcement officers. It served as a stark reminder that assumptions are not evidence, and bias can never serve as reasonable suspicion. The security camera footage remains online today. You can watch it yourself. You can witness a federal judge calmly asserting her rights, detained for the unspoken crime of shopping while Black. You can see the exact moment Hutchins realizes the catastrophic mistake he has made. And perhaps most importantly, you can see what accountability looks like when the system is actually forced to work. The story of Judge Kesha Langford, detained in a parking lot, resonates far beyond the specifics of her arrest. It offers a critical lens into accountability, demonstrating that even when confronted with deeply entrenched bias, the system can be compelled to work. But it also poses a haunting question. What happens when the person profiled does not have her unique advantages? Think about everyone who doesn't possess Kesha Langford's legal knowledge, her federal credentials, or her position of authority. Thousands of Black Americans face similar stops and searches every day, based on nothing more than assumptions and implicit bias. They are arrested for asserting their constitutional rights, often without the resources or knowledge to fight back effectively. Kesha's story highlights a stark reality. Even with every conceivable advantage, bias can still inflict injustice. But it also proves that accountability is possible, that consequences can follow violations, and that systemic change, though hard-won, is within reach. Not every unlawful detention ends with such a clear path to justice. Not every case of racial profiling leads to termination, substantial settlements, and sweeping reforms. But this one did, and that matters immensely. It offers a blueprint for how a single incident, meticulously documented and forcefully pursued, can ignite significant, lasting change. The security camera footage, still available online, serves as a permanent testament. You can watch a federal judge, calm and articulate, assert her fundamental rights while being detained for the unspoken crime of shopping while Black. You can observe the exact moment Officer Hutchins' confident demeanor crumbles, replaced by the dawning realization of his catastrophic error. This footage is more than just evidence. It's a mirror reflecting societal prejudices and the enduring struggle for equitable justice. What is the biggest takeaway from this story for you? What would real accountability look like in every similar instance? This narrative matters because it exposes a systemic vulnerability. It shows how power, unchecked by proper procedure and personal integrity, can lead to devastating consequences for individuals and institutions alike. Kesha Langford's actions post-settlement, donating every dollar to civil rights organizations, underscored her unwavering commitment to justice beyond personal gain. She explicitly stated her purpose: to protect others who lack her resources. This selflessness transformed a personal ordeal into a powerful catalyst for collective good. It provided resources to organizations actively working to dismantle the very systemic issues that led to her arrest. Her story is a stark reminder that while the badges and uniforms represent authority, they do not inherently grant infallibility. It underlines the critical importance of constitutional literacy, not just for law enforcement, but for every citizen. The ability to articulate one's rights, even in the face of intimidation, proved to be a powerful shield for Judge Langford. The reforms implemented in the San Diego Police Department, mandated by the federal consent decree, demonstrate that institutional change is achievable. Mandatory bias training, early warning systems, civilian oversight, body cameras, these are concrete steps that can mitigate unchecked power and promote greater equity. But these reforms often come at a cost, both financial and institutional, prompted by public outcry and legal pressure. Ultimately, Kesha Langford's ordeal is a stark illustration of the power of documentation and persistent advocacy. It forces us to confront the reality that racial profiling is not a relic of the past, but a persistent challenge in the present. It demands that we ask uncomfortable questions about the assumptions embedded in our justice system and the accountability mechanisms in place to address them. The video remains a silent witness, continually asking, how many undocumented Keisha Langfords are there? And what will it take for their stories to also lead to justice?